Two people, same Bangkok café, same Tuesday, same MacBook, same Wi-Fi, same foreign clients. One of them is working completely legally without a Thai work permit. The other is one Labour Department visit away from a criminal record. Same country, same moment, same activity, different legal reality. The difference isn't what they're doing, it's a single visa category printed in their passport. And most people in that cafe have no idea which one they are. The statute that governs this is the Foreign Employment Act, BE 2560, passed in 2017, still fully in force in 2026. And it draws a very clean line. On one side, legal. On the other, a criminal offence, carrying a fine of up to 100,000 baht, approximately $2,800, and imprisonment of up to 5 years. Not a visa cancellation, not an admin fee, a criminal conviction. Here's where the law gets genuinely uncomfortable. Because the Act defines work as, and this is the actual statutory language, exerting energy or using knowledge to do something, whether or not for wages. There is no minimum hours threshold. There is no foreign income carve-out. There is no exception for remote workers whose clients are in New York or London. Under that definition, answering a single client email from a Bangkok cafe on a tourist visa is, on the face of the statute, a criminal act. That is not alarmism. That is the law as written. Now let's talk about what this means for you, specifically. If you earn $5,000 a month from foreign clients and you're living in Thailand on a standard 60-day tourist visa exemption, the kind most Western nationalities receive on arrival, every working hour you spend in Thailand is potentially a criminal exposure. A conviction doesn't just end with a fine. It triggers mandatory deportation and a re-entry ban, permanent in the worst cases. 2 years of border runs, co-working spaces and client calls, undone by a single Labour Department inspection at the wrong co-working space on the wrong afternoon. And those inspections are happening. They are not theoretical. The Thai government has not issued a blanket amnesty for remote workers. There is no informal digital nomad exception written into the criminal liability provisions. What has changed since 2022 is the visa architecture. 3 specific pathways now exist that give remote workers genuine legal cover. But genuine comes with conditions, and understanding those conditions is the only thing that separates the first person in that cafe from the second. Let's go through all 3. The DTV, the Destination Thailand Visa, launched in mid-2024 and is now the most relevant pathway for independent remote workers and digital nomads. It's a 5-year multiple entry visa with stays of up to 180 days per entry. The fee is 10,000 baht, roughly $280, payable at a Thai embassy or consulate abroad. The DTV is designed specifically for people who work remotely for foreign employers or clients and have no Thai employer, no Thai income, and no local business activity. Under current Department of Employment administrative guidance, DTV holders earning exclusively foreign-sourced income and working for non-Thai clients are not required to hold a Thai work permit. The DOE's position is that the work permit requirement is directed at employment relationships within the Thai economy, not at remote workers whose economic activity sits entirely outside it. That guidance is meaningful. It is not, however, a formal ministerial regulation or a court ruling. It is administrative practice, and administrative practice can shift. So what does legal cover actually mean for a DTV holder? It means that if Labour Department officers walk into your co-working space, the DTV in your passport signals that you are in a category the Thai government has deliberately created for remote workers, and the official guidance supports your position. That is not absolute immunity. It is a defensible legal position, backed by the issuing government's own stated intent. That distinction matters. The LTR, Long-Term Resident Visa, goes further. It's a 10-year visa that explicitly includes a work permit for remote employment for foreign companies. No separate work permit application. No Thai employer. The LTR's work permit provision is written into the visa approval itself. The catch: the income threshold. The Work-from-Thailand Professional LTR category requires a minimum annual income of $80,000, with at least 2 of the past 3 years employed by a foreign company. That rules out the majority of freelancers and independent contractors. If you clear that bar, the LTR is the cleanest legal structure available in Thailand for a remote worker. The third pathway, the BOI-sponsored non-immigrant B visa with a standard work permit, is the traditional route and remains the correct one if you have a Thai employer or work for a company with a Thai BOI registration. The non-B is a 1-year visa, renewable, and the work permit is applied for separately through the Department of Employment. Timeline is typically 4 to 8 weeks. Cost varies, but budget roughly 15,000 to 20,000 baht in government fees across the visa and permit process. This is not the route for independent freelancers. It requires an employer-employee relationship with a Thai-registered entity. Now let's be direct about the grey zone, because it exists, and pretending otherwise would be irresponsible. The DTV's legal cover has a clearly stated scope: foreign-sourced income, foreign clients, no Thai employer. The moment you take a Thai client, invoice a Thai company, or earn income that originates in Thailand, the DOE's administrative position no longer clearly protects you. Whether that triggers the work permit requirement under the Foreign Employment Act depends on facts that have not yet been tested in Thai courts in the DTV context. The honest answer is, the legal architecture is cleaner in 2026 than it was in 2022. But it is not clean. If you're a DTV holder with exclusively foreign clients and foreign income, you're in the strongest defensible position available to an independent remote worker in Thailand right now. If you have Thai clients, Thai income, or a hybrid situation, you need a Thai lawyer with employment law experience, not a YouTube video. Here's what practically matters. If you're on a tourist visa exemption doing any form of paid remote work, even for purely foreign clients, apply for the DTV before your next entry. The 10,000 baht fee is not a meaningful cost relative to a 100,000 baht fine and a permanent re-entry ban. That calculation is not close. If your income exceeds $80,000 annually from a foreign employer, the LTR is worth the 50,000 baht application fee for the legal certainty it provides. 10 years, work permit included, no annual renewal anxiety. And if you're employed by a Thai company or BOI registered entity, a valid work permit is not optional. It never was. The person in that Bangkok café who's completely legal isn't doing anything different from the person next to them. Same clients, same laptop, same Tuesday. The only thing that separates them is a document and an application that most people keep meaning to file and keep not filing. The Foreign Employment Act doesn't care where your clients are. It cares where you are when you work. If the answer is Thailand, you need the right visa, not just a good Wi-Fi password. For the full DTV application checklist, LTR eligibility calculator, and updates as Thailand's work permit framework continues to develop through 2026, subscribe to the Bangkok Brief newsletter at thebangkokbrief.com or subscribe to this channel so you don't miss what's next.